great presentation for you today. My name is Jeff Stauffer, Community Relations Director with Elville Associates. A few brief housekeeping items if you haven't been here before. We have restrooms out the door, and to your left we have plenty of food from the lunchbox lady who's been very nice to us over the years, but we do pay them, I promise. We have coffee in the back, and we also have other refreshments as well, so please enjoy. And it's my pleasure to introduce to you once again Mr. Stephen Elville, Managing Principal and Lead Attorney of Elville Associates, and Mr. Gary Greenwald, Principal of the Law Offices of Gary Greenwald, and also our special guest presenter, Mr. Alex Seleznev, Founder and President of Capital Squared Financial. Alex, thank you so much for being here. Really appreciate it. And you have Alex's full biography in your packets today. He's going to actually go second. He's going to go second. Yeah. He's going to go second and back clean up for us. And I'll give him a proper introduction before his presentation. But for now, I'm going to turn it over to Gary and Steve, and we'll get started.
Good morning, everyone. And if I'm too loud, please tell me. We've got lots of recording going on here today. We have cameras recording. We have Danny Greenwald, who's here to help us with our audio. Danny is an expert podcaster and has several podcasts with the BBC, so we appreciate Danny being here this morning. His significant other, Rebecca, is here to help us with the camera. And thanks to Jeff and everyone here who got here early. Happy Saturday and happy April to you. Happy spring. Also, I want to recognize that some of our members here today, for example, Nancy Abel is here, or will be here with her granddaughter. Is she here yet, Nancy?
Not yet.
Not yet. She will be here. So we have a 10-year-old granddaughter here today. So we welcome that. Stephen LaRocque is here. Stephen is an actor and a producer and writer, director. Stephen, anything? Now we're cutting out again. Sorry about that. Is Zach still here? He could give us another microphone? Oh, thank you, Gary. Stephen, any announcement about what's happening in your world of theater and directing?
Sure. Yeah, I have, as I've mentioned before, I've been still doing the one-man show that I developed. It's been running for about 12 years. Ernie Kyle, the World War II reporter, and we're booking back to the Montgomery County Speakers Bureau, mostly in Montgomery County, although we've traveled as far as Baltimore and Pennsylvania to do it. But a new opportunity that's pretty exciting is one that I've written and am directing. And a young lady named Kathy Mack, who's a graduate of Mount Holyoke College. Any Mount Holyoke grads here? Class of '64. She's going to play Frances Perkins, who you may know as Franklin Roosevelt's Secretary of Labor. She was actually the third longest serving cabinet member in American history. And so we're doing a one-woman show up in Mount Holyoke for the reunions in June. So we're rehearsing for that, and that's pretty exciting. Thank you.
Thank you, Stephen. And we know we have some new members here today, so thank you for coming. One of our new members, Stephen Valen, is here. Thank you, Stephen, for coming. And Tim and Brenda Helsing in the back, thank you for coming. And Gary, I don't know if you have any new members here for the first time, but you're welcome to introduce them as well. And I just again wanted to thank Zach from Anne Arundel Community College, Danny and Rebecca for being here and really having professional audio today. And again, Alex Seleznev, who's going to come up. He is the energy, he's a tennis player, and he just told me that he is a platform tennis player, which I've never heard of, and a play in a cage. So I thought, wow, okay, something's happening here. So Alex is going to tell us about that. Gary, any opening comments?
I'm just impressed that we have a speaker here who's experienced in cage matches. No, I have no further. We're looking forward to this morning. So Steve and I are going to start. We're going to talk about powers of attorney, then we'll take a quick break, If you haven't gotten the lunch in the back, please help yourself. And Steve, why don't we start?
Sounds good. All right, so we appreciate your commitment to get into this and look under the hood, so to speak, in powers of attorney, which, really takes a commitment to do that. And I personally think it's one of the most important things in estate planning. So I'll start by saying, in 2016, I went to the Heckerling Conference in Florida, and one of the prolific estate planners in the world, who's now retired, Jonathan Blattmacher, who was a prolific estate planning attorney in Manhattan and behind many IRS rulings and started a trust company out of Alaska. I mean, he's just a very prolific guy. He stood up in front of the group, as many of you may have heard me say before, and said, what is the most important document in estate planning, now think about that, in the world in 2016, and that was the year I was at that conference. He said financial powers of attorney. Now remember, Jonathan Blattmacher deals with billionaires and all kinds of people. And he still said that financial power of attorney is the most important of all the documents. So I personally believe that's true, and I think most attorneys believe it's true. And we're going to get into the origins and evolution of financial powers of attorney, the design of financial powers of attorney, and some of that importance of powers of attorney is going to come out. It's going to come out in this discussion. If you have never heard of that before, hopefully it will kind of present itself like a lot of the education does. How financial powers of attorney fit into various estate plans, which most of you are familiar with already. The risks associated with financial powers of attorney. So they are wonderful, but there are risks. The Maryland Power of Attorney Act, the newly updated Maryland Statutory Power of Attorney. So the legislature updates that form every once in a while. And notes to fiduciaries, what do you do at a time of crisis? And of course, we want you to keep your powers of attorney updated, which is part of the client care program. So Gary and I, I'm sure, both agree that behind all good estate planning, we have goals, right? So you know that, and that's what your commitment is. But many times we don't really think about being intentional with something as mundane as financial powers of attorney. So all incapacity planning, I personally think, should be goal-driven as well. And Gary, you just jump in whenever you would like. And by the way, Gary, they only had one microphone working this morning, so we can always use this one as well. So that one's on right there if we do want to use that one. And you can always use this handheld as well. So why is it critical to maintain and update your financial powers of attorney? Well, we're not only providing certainty for loved ones at our deaths, but we want to provide certainty during life. We want to provide for the thing I'm really focused on a lot of times is flexibility. We want to provide for flexibility for people over periods of time, okay? Facilitate smooth management, avoid confusion and disruption, avoid guardianship. Now, a lot of this stuff just is, one bullet point after another on a Saturday morning, and it's heavy stuff. But I'm going to set the stage for this. Many of you have dealt with tragic situations, and I'm sorry that, it's a beautiful day here and we're talking about tragic situations, but we're talking about incapacity planning. So someone calls me up about 3 months ago and says, this was a well-known CPA that I've worked with, and he said, Steve, my sister has a brain tumor. Okay, so God knows many of you have dealt with similar situations. She's in a hospital. What do I do? She has three kids under 21. What's the first thing that I would ask? Or what did I ask? Does she have a financial power of attorney? So why did I ask that question? You notice I didn't ask, does she have a healthcare directive, which maybe I should have asked that too. But I asked, does she have a financial power of attorney? Because what he was really concerned about was, what can I do with her house? What can we do for the kids to preserve assets? So when he told me that she didn't have a financial power of attorney, what was my next thought? Well, gosh, we don't have much flexibility to really do anything. Why would I say that? Because there's no substitute for guardianship when someone is borderline incapacitated or incapacitated. You either have a financial power of attorney and an agent under that power of attorney, or you don't. So thank goodness she still had mental capacity to be able to sign a power of attorney, and we were able to get out to the hospital and have her sign it. But that was why that was the first thing I asked. What I'm really asking is, Do we have flexibility here, or do we not have any flexibility? Why would I say that? Because if you see up here, we're avoiding adult guardianship and the loss of rights, okay? If she did not have the capacity to sign that power of attorney, which thank goodness she did, her assets still would have been preserved for her, but we would not have had the flexibility to do certain types of things that we otherwise could have done. So we could have gotten guardianship, her property would have been managed, it's just that we wouldn't have had as much flexibility because it would have been under the auspices of the court. Any comments here?
Yeah, first of all, regarding guardianship, what you want to keep in mind is this. A guardianship is a process that the court supervises to make sure your assets are managed correctly. But a guardianship is a public process. Any type of guardianship is subject to public scrutiny. The public can go down to the courthouse and see what's in the guardianship file. So think about this. The petition for guardianship sets forth what your disability is and the type of assets that you have and the value of those assets. That all becomes a matter of public record. So the first problem with guardianships is that the public has access to your own personal information. Secondly, it's up to a judge to decide who your guardian will be. So you really have no control over that ultimate decision, who will be in charge of your things. Third, the attorney's fees for a non-contested guardianship can run $4,000, $5,000 and up. Fourth, once the guardian is appointed, it's the guardian who decides how your assets will be used. So you've lost control over who will be in charge. You've lost control over how the assets will be used. You're leaving that up to somebody else. You've given up control. And the court costs involved in a guardianship can be prohibitive. Although the filing fee for a guardianship is about $170, $180, which is not an insignificant amount, but relatively speaking, not all that much. The real cost with the guardianship, in addition to the attorney's fees, is the bond that the guardian has to put up. The bond can run hundreds, possibly thousands of dollars a year, depending upon the value of your assets. Because remember, your retirement accounts are all subject to guardianship. So if you've got $1 million, $1.5 million just in retirement costs alone, the bond itself can run hundreds, again, possibly thousands of dollars a year. So at guardianship, you lose control. With a power of attorney, you can dictate a lot of these types of issues.
Thanks, Gary. So along those lines, avoiding court involvement, achieving your special purposes. We just talked about asset protection in that long-term care situation for that person that was ill. Tax reduction, asset preservation, and the funding of estate plans. And to assure that your goals are achieved. So that's what we're really going to get into here. Let's define what a power of attorney is. It's an instrument granting someone else, your agent, the authority to act for you, the principal. Okay, so that is really kind of a basic definition. And now I'm going to test your thoughts and skills here this morning.
If you go back one slide,
Sure.
I want to point something out.
Yes.
You see on the bottom of this slide a book referenced Black's Law Dictionary. How many of you have watched on television the show Suits? Anybody? All right, so if you remember, what was the name of the young guy, the young person who didn't go to law school but became an attorney? If you remember in the show, he actually memorized every page in Black's Law Dictionary. That's the first book that any law student purchases when he goes to law school. I was impressed with that.
Wow, I'm impressed too, Gary. I'm worried about him too, but. All right, so financial power of attorney, what is it? Well, you're going to form your own definition here. So I'm going to give you an answer key on the next slide. But a financial power of attorney is, in my opinion, a lifetime tool to help pay my bills, take care of me, take care of my spouse, and for those of you who have dependent children or persons, loved ones with disabilities, to take care of any person who is dependent on you, on me, manage my financial affairs, provide flexibility at a time of crisis, my mental incapacity, not my physical incapacity, facilitate the accomplishment of my goals. This could be estate-related, tax-related, asset management-related, preservation-related, during any time when I cannot act for myself. So that's a key for you. You can always look at that later.
Steve,
Go ahead, Gary.
what I do want to make with powers of attorney, if you go back to the slide, if you see on line, the first line, a lifetime tool, what that means is this: the power of attorney is only effective while you're alive. I've had many clients come to me with the understanding that the power of attorney can still work after the person who signed the power has died. Those of you who are clients of mine probably remember me telling you about William Colby, the former head of the CIA, who went missing, I think, in the 80s or 90s for about a week or two. So think about it. If he goes missing and his wife had a power of attorney, and she takes the power of attorney to the bank, the first thing the bank is going to ask her is, well, where is your husband? Where is Mr. Colby? And if she says, I don't know, if the bank is doing its job, it will decline to honor the power. Because if the power of attorney is only effective during your lifetime and you go missing, they couldn't say for sure if he's alive or not. So just keep in mind the power of attorney terminates upon the death of the principal.
Thank you, Gary. Okay, for those of you who understand your will structure, you see here that your financial power of attorney is part of your will plan. For those of you who have a will, what controls everything if you become incapacitated? Your financial power of attorney. It controls all assets. Versus those of you who have a revocable trust, okay? You know you have a financial power of attorney as well in a revocable trust plan. And here, the revocable trust controls what? All non-retirement assets. Mutual funds, stocks and bonds, cash, CDs, savings bonds, anything that would be titled in the name of the trust.
Steve, why would it not control retirement assets?
Well, Uncle Sam loves that. They hope that we're going to try to title our retirement assets in the name of the trust because they can trigger all tax on the retirement plans. So obviously we don't want to put retirement plans in a trust, Gary, because it would trigger all tax. So that has to stay outside of the revocable trust, and that's controlled by the financial power of attorney. Just like life insurance would typically be outside of the revocable trust. So qualified plans, IRAs, all those things stay outside of the trust, but the revocable trust controls the non-retirement assets. So the power of attorney and the revocable trust, for those of you who have trust, they work together to be incapacity tools. Okay, so in a will-based plan, we just said this, all assets of the individual are controlled by the financial power of attorney. But what does a power of attorney control? Does it control jointly owned assets? Gary?
It could. Generally, a jointly held asset, owned usually by two spouses, either spouse can act on behalf of that asset. But a power of attorney can authorize with the principal, if the principal is a co-owner, to sign his or her name. So the answer is the power of attorney could actually affect jointly held assets.
Powers of attorney can control, and do control, IRA assets, beneficiary designated assets like life insurance. Powers under a life estate deed. A life estate deed is where someone has a life estate in the property and the remainder beneficiaries get that property at their death. Assets held at transferable on death, TOD, are controlled by power of attorney. Assets held payable on death. You have a payable on death account down at the bank. That's controlled by power of attorney. And we just talked about retirement plans and life insurance. So understanding that non-probate assets, okay, are going to be controlled, generally speaking, by powers of attorney, okay, unless it's titled in a trust. And then depending on how those things are titled, they pass by right of survivorship or transferable on death and so forth. Just remember, those assets are generally controlled by powers of attorney. Understanding just what Gary said, how things are titled and what controls what, is so very important. But as part of that, understanding how assets flow at your death. So one of the earlier slides talked about powers of attorney can be used to make sure your estate plan is funded. Many of you have powers of attorney that say, if I'm incapacitated, my agent can change my beneficiaries. Some of you don't have that power, but others do. And that's a fiduciary power to do what? Make sure that assets are flowing right, or power to fund my revocable trust, make sure that assets are getting into my trust if I didn't put them in the trust during my well years. So these powers of attorney are just, on and on, very, very important. Go ahead, Gary.
So first of all, I get this asked a lot. If somebody has a power of attorney, can that power of attorney be used to change the terms of a will? If you have a will-based plan, the answer is no, it cannot. As far as giving an agent the ability to change your living trust, keep in mind a living trust is a contract. Like any other contract, there are parties to the living trust. You have a person who's making the trust and a person who is the trustee, and of course there are beneficiaries. Generally, if you want an agent to change the terms of your trust, you would want that in the actual trust agreement. In the power of attorney, you can opt to have somebody else change the terms of your living trust. I've always counseled clients not to give anybody that ability, because basically you're giving up control as to where your assets will pass upon your death. So that can be provided in a power of attorney, allowing somebody else to change the terms of your trust. I always thought it was a bad idea. I don't know about you, Steve, but I don't like doing that.
Yeah, I don't think we generally want to do that, but there could be exceptions, right? There could be a case-by-case situation where someone would want another person to be able to do that, but generally not. And of course, powers of attorney become effective either immediately. We're going to talk about the history of powers of attorney for those of you who are really wanting to understand the history. And that was not always the case, that it could be effective immediately. And then it can become effective upon the incapacity of the principal, which is you. And then, of course, it could be not only immediate or subject to proof of your disability, but it also could be held in an escrow arrangement, where no matter when you say it's effective, you're limiting the access of your agent to be able to get the power of attorney. Some of you want that, and for others of you that doesn't make any sense. But these kinds of arrangements are thoughtful things that you should think about, given the scope of the authority that you can give your agent.
Yeah, if you go back to the last slide for just a second, you see on the bottom, and Steve mentioned this, a springing or contingent power of attorney. It used to be years ago that a power of attorney is effective immediately, but if you become disabled, it automatically becomes ineffective. And so you had to create something called a durable power of attorney, specifically allowing the agent to act if you become disabled. Back, I think in the early 80s or late 70s, the law changed in Maryland, and now generally a power of attorney is effective if the principal becomes disabled unless the document says otherwise. So you've seen the term many times, a durable power of attorney. That really is, it's not an effective term nowadays, because all powers of attorney without language to the contrary are durable.
All right, so we want to understand that we're avoiding guardianship. We talked about guardianship a little bit a few slides ago. Just remember that even if you have a power of attorney, which I know all of you do, you have to make sure you don't run out of agents, right? You could still have a guardianship if your agents fail to serve. We want to make sure our agents are willing to serve. Make sure that, God forbid, if our agent passes away or is incapacitated, that we appoint new agents, right? This is easier said than done sometimes. But we're avoiding guardianship of our property. So we're going to talk about the history and evolution of powers of attorney here. We talked a little bit just a moment ago about durable and non-durable powers. The Maryland Power of Attorney Act in 2010, the Maryland Statutory Power of Attorney, which just recently changed in October of 2023 because the legislature updates these documents. We're going to talk about asset protection and the duties and responsibilities of an agent. So the history and evolution of powers of attorney dates back, believe it or not, to 400 BC, from what I'm told.
That's when I first started practicing.
I wasn't going to mention that. And it's a contract. And the principal, as we mentioned earlier, gives the agent authority. And at common law, the agent was not authorized to act unless the principal had the ability to act for themselves. So think about that.
What is common law?
Common law is the Old English law that developed from, I guess, historic times in England and the British Empire. So Think about this, you know, if I don't know the exact dates that this evolved, but let's say it was 1850, and I give Gary the power of attorney.
That was when I became 30 years old.
I must have lost my mind if I did that. But I give Gary the power of attorney, and then I took a trip out of London, and 300 miles out, I become disabled. Would Gary be able to act for me? No. His authority to act for me ended when I could no longer act myself. So that didn't work too well in the Industrial Revolution and as history evolved and society evolved. So that did not work well. So the law had to evolve, and now we can have a durable power of attorney. We can create it, and if we become incapacitated, the agent's power continues. Okay? And statutorily, these things started being updated in the 50s and 60s. The National Conference of Commissioners on Uniform State Law created the Model Act in 1964. And then there's something called the Uniform Probate Code that evolved about powers of attorney. And then the Uniform Power of Attorney Act in 1979. Basically, all states started recognizing some form of durable power of attorney. And then courts are kind of getting involved. Cases involving lifetime gifting, okay, and changes in people's estate plan. Should an agent have the authority to do what Gary just said, change an estate plan or make gifts, right? So those of you who have powers of attorney, and I know all of you do in this room, you either provided for gifting power in some way, limited or very broad gifting, right? And for maximum flexibility, you would have provided very broad gifting. Why? Well, for various reasons. Long-term care planning, estate tax planning. Maybe you just wanted to have your charitable gifts continued because you'd always make gifts to charity throughout your life, or your church or synagogue. So all of these things are built into the powers of attorney, but they all evolve in the law. If that power of attorney does not provide for gifting power, is there any gifting power, Gary?
No.
All right. So if it's either in there or it isn't. And these are some of the big powers that you just kind of want to have a healthy awareness of. So statutory powers of attorney were enacted. I remember when I first became an attorney, one of the first out-of-state powers of attorney I ever saw, of course, was DC power of attorney or a New York power of attorney. And these are statutory forms. If you lived in those states, you can use this form and you can have the confidence that you can have a power of attorney that works. Well, finally, Maryland has that in 2010, and it's evolved since then. We're going to get into that a little bit. So the non-durable power of attorney, the agent cannot act for the principal. Of course, we're not living in that world anymore. The durable power of attorney, the agent's power, survives the principal's incapacity. The power, is not affected by the subsequent incapacity of the principal or by periods of time. So we now live in a world of statutory and non-statutory powers of attorney. Gary, do you want to comment on the statutory forms or how you approach your practice? I know you use mostly the statutory form.
I actually use two powers of attorney. I use the Maryland statutory power of attorney. I use also something called a durable special power of attorney. And the Maryland statutory power of attorney under the law is enforceable. What does that mean? It means that if a third party, if you take your power of attorney to the bank or to your financial advisor, and you are the agent, and your principal authorized the agent to make decisions, if the third party, the bank or the financial advisor, declines to honor the power of attorney, you can actually file a lawsuit in Maryland, have a judge sign an order to enforce the power of attorney, and actually get attorney's fees awarded should you win the case. And the problem though with that is that if a power of attorney is going to be effective, it really needs to be effective immediately. Despite the fact that powers of attorney are enforceable in Maryland, some of the large national banks don't honor them. I had a case, I won't mention the name of the bank, but it's a well-known bank in America, so you put two and two together. And what happened was the husband worked, the wife did not. The husband had health care insurance, the wife of course did not. The husband had a stroke on the 3rd of December. I remember this date specifically because it was 3 days after my birthday. So the husband had a stroke on December 3. On December 5, the form arrived at the house for the husband to sign his name to continue the health insurance policy. But of course, he couldn't sign his name. Because the wife was able to sign the husband's name, she was able to sign it, she did, and the health insurance policy went on. I had another case where the husband became disabled, the wife was designated as his agent, and this account was at this particular bank located here in America. She took the power of attorney to the bank, and the bank refused to honor the power of attorney. So she calls me up very angry because she said, "You told me that this thing was enforceable." Well, it is under the law. So after about a week of trying to figure out where this legal department was, I finally got through to them, and I spoke to the attorney who represented this bank, and I said, "Look, my client's at your branch, at the Ellen Brown branch in Columbia, Maryland. She had the husband's power of attorney, and the bank did not honor it." And the attorney said, "Yeah, we've been waiting for this phone call because the manager called us about it." And I said, "You know, we have a law here in Maryland that says that if you don't honor the power of attorney, we can actually file a lawsuit, get an order to have it enforced, and get attorney's fees awarded." And the attorney said, "I'm aware of that as well." So I said, "So why won't you honor it? We can do this." And the response was, "Nobody's going to do it. No one wants to finance a lawsuit for 4 or 5 months, maybe you get attorney's fees and maybe not." After whining for about a week and a half, and believe me, my wife will tell you I can whine very effectively, I finally figured out a way of getting them to finally honor the power of attorney. But the point is, the law does say that you can have them enforced in Maryland. Powers, you know, you have the law and then you have real life. So although I think powers of attorney are the most powerful document you can have, there are reasons to also have a living trust, because if you have the trust, then the successor trustee becomes the legal owner of the property, not necessarily the beneficial, and they have a little bit more power. But I will tell you that there are certain banks in Maryland that will not honor the power of attorney, usually the larger ones. So if you think it may be needed relatively soon, you want to take the document to the bank and get some type of a written acknowledgement that they will honor it. And if they won't, go back to your attorney. The attorney can contact the legal department and say, "All right, what can we do to solve this? Why don't we use the Maryland statutory power and add whatever provisions the bank would feel comfortable if they were asked to honor it in the future."
Gary, those are, yes.
So if you have a joint account, does that preclude needing a power of attorney to get access to the funds?
If it's a joint account, then either party can withdraw and make deposits.
Thank you.
Gary, what about title companies? Or title attorneys, that's where we really see sometimes the problem. Somebody trying to convey real estate, and our title attorney colleagues will say, "Oh, this power of attorney is 5 years old, I don't like the way it looks." Have you had that?
I've had that. I will tell you again, in Maryland, as long as the document is signed, it's done consistent with the statutory Power of Attorney Act, it's witnessed by 2 people and notarized, they are enforceable. So I have had title companies do that. Usually what will happen is they'll call me a week or 2 ahead of the settlement. If they have an issue, I'll just have the client come in and re-sign the power of attorney.
Okay, we're going to keep, yes, Stephen?
Why are these banks reluctant to accept the power of attorney? What's the reason?
I will tell you, in my experience, especially that one, they didn't give me an answer. They just said, "We don't like it. We've never used these before. We have our own powers of attorney with which we're comfortable, and that's the one we'll use." In my opinion, it's also because the attorney is trying to justify his or her salary. There's no reason in Maryland not to honor them because the law says they're enforceable. But I've never gotten a logical reason that makes sense in the few times I've had the problem.
And I would do what Gary suggested, which is grease the skids by giving them the document and say, in 72 hours, I'd like to come back and make sure that your attorneys have approved it. And if that doesn't work, I would switch banks, seriously, because we don't want to run into that problem at a time of crisis.
Some of my clients here have probably heard that advice from me, that if you go to this particular bank, they're not user-friendly, and your last line of defense is if you don't do what I'm asking you to do, which is a perfectly reasonable and legal request, we're just going to take our business elsewhere.
Okay, we're going to keep going to finish on time and get Alex up here. Statutory power of attorney then is a power of attorney created by state law, and it's promulgated by government forms. If we took a Code of Maryland law book, opened it, there it would be right there. It's governed by legislation, it's updated by legislation, and one of the recent updates is something I would like to talk about before we end. So, the Maryland Financial Power of Attorney Act was enacted in 2010. I don't know if those of you remember things prior to 2010, but if you're on my side of the fence, and Gary will attest to this as well, we would see some terrible powers of attorney drafted by other attorneys. Clients coming in with powers of attorney that are just really shoddily drafted. Power of attorney from 1999, and the banks won't honor it because it just doesn't look right, it's sloppy. And so the 2010 Maryland Power of Attorney codified the responsibilities of an agent, made the power of attorney enforceable by law, got Maryland up to speed. Now we are kind of in the same category as Delaware and West Virginia in that we have a statutory power of attorney. It addresses fraud and abuse. Does fraud and abuse still exist? Yes. And it's terrible. Elder abuse is terrible. Officer Andre Lingham, who many of you have heard, now says elder abuse is up to, I want to say, Jeff, 135 billion a year. It's quadrupled. So we got to be very careful about these powers of attorney, especially since most of you have probably provided for massive flexibility in these powers of attorney. But the law does address this and the responsibilities of an agent. Gary, can you ask an agent to be accountable?
No, in Maryland, the law says that an agent is accountable. Under the new statute, there are a lot more elections that can be made as far as powers of attorney. But in Maryland, an agent who breaches his or her fiduciary duty, which is the highest duty of care that anybody owes to somebody else, can be accountable for any losses as a result of serving in that capacity. If the agent is charged with the preservation of assets and they make incorrect or bad investment decisions, they can be responsible. Yeah, sure.
Thank you. All right, so we know we can hold our agent responsible, or the other people who have standing in the family can hold that agent responsible. So the Maryland Power of Attorney Act is in Title 17 of the Maryland Estates and Trust Code, and you should have a handout. And what we gave you is the big Maryland statutory form called the Limited Power of Attorney. And so this is one that is in the law. In my opinion, Gary, this is a fine power of attorney. What does it lack, though? It lacks, to me, flexibility. Statutory powers of attorney are not supposed to be altered. We're not supposed to, as attorneys or officers of the court or whatever you might call it, we're not supposed to change this form. But are there plenty of attorneys that do, Gary?
There are always attorneys, usually those who are not real experienced in estate planning, who will. There are certain provisions that I think are safe to put into a power of attorney, but I've seen some very imaginative additions to powers of attorney, which underscores really the importance, if you go to an attorney to have a power of attorney prepared, make sure that he or she is experienced in this.
Right. So if someone had to enforce the power of attorney, Gary, would they want to enforce one that had been altered, or would they want to enforce one that looked like a Maryland power of attorney?
If I were defending a power of attorney, I'd want to defend one that is the statutory form. If I'm prosecuting a power of attorney, I'd like to see as many amendments and changes to it as possible.
And so Gary always has better jokes than I do. But anyway, this is the short form power of attorney. So this is what many of you as clients of Elville and Associates have, in addition to the general, durable, customized, so to speak, power of attorney that we use in a two-step process with powers of attorney. So just know, both of these are fine. Both of these are enforceable by law. The larger one requires more choices and more initials and more thought that goes into it that we, on our side of the fence, generally customize into a separate general, durable power of attorney. Just both of these are fine powers of attorney.
Just keep in mind what the law says is that as long as the power of attorney is the same or substantially similar to a published power of attorney that the legislature's put out, they are enforceable. Now, what does substantially similar mean? I guess, that's in the eyes of the beholder. But as long as it closely follows the statutory form, and the key is, again, as long as it's signed before 2 witnesses and a notary, and one of the witnesses can be a notary, then they'll be enforceable in Maryland. Question?
Between the two forms, is there any significance to the fact that the short form includes the words personal and financial, and the long one doesn't?
No, not really. And that's just the heading.
Can you tell us what he said?
He asked if there was a significant difference, and correct me if I'm wrong, if the power of attorney at the beginning has the term personal financial power of attorney. It's really the body of the document and not the title that's going to be definitive.
Okay, so let's talk about the most recent legislative updates as you look at the simple or short form power of attorney. I'll just tell you that I personally was against some of these changes. I'm the past chair of the Elville Section Council, and they let people who are the past chairs still be part of the process. So I knew that the Elville Section of Maryland was behind, let's just say, providing more and more advanced powers in these simple powers of attorney. Now remember, and I always make clients, or try to make clients laugh about this, I always say the simple Maryland power of attorney form, or even the larger one, is really for the average person. And what I mean by that is the average person who lives and works in Maryland, whether you are a person who works here at the college, or you work at the mall, or you're a CPA or a financial advisor, anybody who lives in Maryland can have a Maryland power of attorney and expect that it is enforceable by law, because we should be able to have that assurance. But to me, the average person is not the person who does estate planning. You are not average persons at all. You have, many of you, financial advisors, you have lawyers, you have estate plans, you have assets. The average person in this country does not have an estate plan. So where I'm going with that is, the Maryland power of attorney is usually not enough, and that's why you probably should plan with a general durable power of attorney in addition to this. But what the legislature saw fit to do recently is add some additional powers to this that the average person would probably not have any education on. One of those powers is on page 5. Now, many of you in the room don't have the latest version of this yet, or many of you might have already signed the latest version. I just want to point this out, and Gary, I want to know if you have any comment about it. The joint account power, I thought this power was kind of scary. This power, if you do see the simple Maryland power of attorney on page 5, to me, this gives the agent the power, or invites the agent to open up a joint account. And I'm not saying that your agent or mine would do this, but it gives an agent the power to create joint accounts. And what happens with a joint account? They get to inherit by operation of law. So I think some of the powers that are put into the Maryland power of attorney, you just want to look at pretty skeptically and decide, do I really want that, or do I want to take that out? Any comments,
Yeah,
Gary?
it's actually worse than that, because if an agent takes money out of your account to create a joint account with him or her, not only would they inherit what is left in that account upon death of the original owner, they actually have the power to withdraw money during the principal's lifetime, because it's a joint account. So that is one of the options on the forms that I've been providing to my clients, and I've always counseled not to do that.
And look at page 7, and we'll try to be humorous about this. This is something that you would either...
Which one are you looking at that says Maryland?
Page 5.
Yes, the Maryland statutory form personal financial power of attorney. I should have said that, personal financial power of attorney. The smaller one. And we were just looking at the joint account power, which is an optional power that can be taken out. And I personally think it should be taken out. Gary will have his own opinion about that. And then page 7 is a new power about the elective share. So those of you who have sat in meetings with me know that I'm always telling people, well, if you ever remarry, you should get a prenuptial agreement to protect your family, so that a spouse could not elect against your estate and get 1/3 of all of your assets, 1/3 of your retirement plans, 1/3 of your revocable trust, unless you specifically wanted them to. So you want to protect yourself if you ever remarry, and we all know about that to a certain degree. Well, this is something I just want to point out. There's probably no downside for you to leave this in. This is one of the new optional powers. And it basically says this. And this is both funny and sad at the same time. If you remarry, and God forbid your new spouse were to die first, what would they likely do? They might leave all their assets to their family and disinherit you. So if you had no prenuptial and they disinherited you, this would give your agent, whether this is tasteful or distasteful, this would give your agent the power to make a spousal elective share claim against the estate or trust of your predeceased second spouse or new spouse. So that's a strange power, but I wanted you to know that's in there. Gary, any comment on that?
I've got just a 2-syllable response to that problem, and it is prenup. Okay?
I thought you were going to say, where do I sign up for that? Okay, sorry. Okay, so just know that these new powers are strange, and we've never had these kinds of powers, and you have the option to have them or not have them. Okay, now, how do we think about asset protection with regard to powers of attorney? Well, some of you have long-term care insurance, you've done very well in your investments and savings, and maybe you don't care about protecting assets from long-term care costs as much as someone else might. But you can build these kinds of flexibilities into your financial powers of attorney to protect for long-term care. And as we think about lifetime asset protection, okay, you can use a financial power of attorney to retitle assets in certain ways with a fiduciary responsibility. So you can use these financial powers of attorney for certain aspects of asset protection. Asset protection at death is not something that I think that financial powers of attorney would apply to, but I want to talk about an option outside of a financial power of attorney to maybe plan for asset protection at death, even though financial powers of attorney may not apply to that. So asset protection during life, right? Tenants by the entireties, spousal ownership of property, life insurance, protected from the claims of creditors, as long as your spouse or child is the beneficiary. Annuities, protected from the claims of creditors, as long as your spouse or child is a beneficiary. Why am I saying that has anything to do with the financial power of attorney? Well, remember, you can give your agent the power to change your beneficiaries. So what if your beneficiary was wrong? Or what if your beneficiary was not listed as, probably not going to happen, but what if it wasn't listed as a spouse or child? The financial power of attorney can give that person, your agent, the power to change that and fix that. And now you would have asset protection. Go ahead, Gary.
I'll tell you why I don't like that. What if you are married, you have children, and you've given the power of attorney to a third party? Could the agent then have the ability to sign your name to make the agent the beneficiary?
Well, that's a great question. So I used to work at a firm in Rockville where the attorney was nationally known and ranked by Forbes magazine in the top 100 in the United States. And he would have provisions in his power of attorney that were like that. Very scary stuff. But those of you, at least on our side of the fence at Elville & Associates, if you've included that power says this, Gary. It says you can change my beneficiary designations, you can fix a situation in a fiduciary capacity, but you can only use the beneficiary as beneficiaries, those persons who are named in my will or trust. So that's a good point that you're making. Okay, so in the interest of time now, Jeff is holding up his hands that we have 5 minutes. We can use long-term care powers to do pre-crisis planning, okay? What if you wanted to preserve assets for long-term care purposes, despite all other planning that you did? You could give your agent so much power that they could transfer assets, do Medicaid-type planning, even if Medicaid is never applied for, but still plan for the possibility of Medicaid and putting assets out of reach for long-term care purposes. Veterans Trust, Medicaid Trust, use of establishing trusts under wills. So crisis planning. What if that person who, God forbid, was in that hospital, what if she had the proper power of attorney? What if she hadn't died, but had been in long-term care now for 3 years after that? and she had 3 children at home under 21. Well, if she had a very broad power of attorney, what could have happened? Even if she was single, which I think she was, probably half of her assets could have been preserved under a proper power of attorney that provided flexibility that she could have gotten long-term care and still protected half of the assets. And that's the bullet point here called the rule of halves. Many of you have accumulated wealth and you've done a great job and you're never going to have to worry about this kind of thing. But for your loved ones or others who have not self-insured for long-term care, financial powers of attorney can be used to preserve assets. And sometimes we can preserve 100% of assets, sometimes we can only preserve 50% of the assets. And as we start to wrap up, trust planning for spouses and all of these things, we can't really use financial powers of attorney for some of these things per se. But remember, Gary, can we use a financial power of attorney to establish a trust?
The answer is yes. It used to be that in the original statutory powers of attorney, that was an option. But now it is in, you can't put it in a power of attorney, but again, generally, at least the trust that I prepare, I have specific language that does not allow somebody else to amend a trust. Because keep in mind, a trust operates as a will substitute. You really want to give somebody else the ability to change your will. Of course, you can't in Maryland, but you wouldn't want to. Same thing with a trust, because a trust determines who will receive your assets upon your death. I'd be very, very hesitant to give somebody else that power.
And along the lines of what Gary's saying, and he's very wise to be cautious about that any power to give someone the power to create a trust, a new revocable trust for you, or an irrevocable trust for purposes of the asset protection we just talked about, would have to say that that trust could only be similar or exactly like the one you had already created. So you wouldn't just give someone carte blanche to create a new trust. You would say it has to be a mirror image of the one I have already created. But you can use these powers to preserve assets. So lastly, the last thing I'll say is, even though it has nothing specifically to do with powers of attorney, you should be aware that when it comes to structuring trust or holding assets in further trust, Maryland has a new decanting statute. So decanting, remember, is the ability to amend a trust or take an old trust, not a revocable trust, an irrevocable trust, and change it to a new trust, which at first sounds very weird and very threatening. But I'm very happy with this law because it brings Maryland back up to speed to where we should be with other states, and it would allow a trust to be amended that really needed amending. Or if extraordinary circumstances occurred, that an old trust could be changed to a better trust or a more flexible trust.
I think in both of our trusts that we create, we also have the provision called a trust protector. A trust protector is a relatively new concept in the law. Now, if you're inclined to mine and you have a trust and you're married, you're going to find that language in Article 16 of the trust. If you're single, I think you'll find that in Article 13 of the trust. A trust protector is a neutral third person who can be appointed either by the trustee or by the then beneficiaries, who have the limited ability to amend your trust even after you pass away, to correct any mistakes or any administrative provisions in the trust, which, if the law has changed, might change your testamentary intent. And some trusts, and Steve, you might have this, you can actually appoint who your trust protector will be. I generally don't do that because the person who you may appoint today as your trust protector may be the wrong person you want 10 or 15 years from now.
Thank you, Gary. And lastly, so we can end on time, your agent has a duty of what? Fiduciary responsibility and loyalty, okay? Care, confidentiality, competence, diligence to preserve and protect the assets, to account and keep records, okay? How many people actually do that? Well, they should, because if they ever have to account, it would be really tough for them to have to try to account. So they should keep the records. They have to use the principal and income for the benefit of you or a spouse or someone who's dependent on you. No self-dealing for themselves. Communication with you or others around you. Information, provide information. And of course, they have limited liability as long as they are acting within their fiduciary duty. Gary, any final comments as we invite people to keep their powers of attorney updated?
No, other than it's a very important subject. I will tell you that after today, and I think Steve's firm will do the same thing, we'll also send out to everybody who's attended here the PowerPoint presentation, so you'll have that. And in a few weeks, this event will be recorded. Once it's edited, you'll also get a link to be able to view this for future reference.
All right, thank you. Jeff, do you want to take a 15-minute break?
10 would be better.
10 is better, Jeff says. And we didn't bring the cage for Alex, but he's going to start in 10 minutes. Thank you.
And have a profile there, or maybe even if you don't, follow Alex. He has some amazing content on there, and I look forward to his Wednesday newsletter at 7:30. Covers a lot of different areas. A lot of people just post things just for the sake of posting it, but he posts things 2-3 times a week that is just really concise and at one point, just really well done. So I would encourage you to follow him. So I want to turn it over to Alex and let him share just a bit more about himself. We have his full biography, which is very extensive, and you can read through that. But I'm going to turn it over to Alex and give him the time that he deserves and into his presentation.
Thank you, Jeff. Really appreciate it, and thank you everyone for joining us today. And of course, thanks to Steve and Gary for inviting me. I'm glad this finally happened. I know we had to reschedule a couple of times, so it's a beautiful day here in Maryland. So to resolve the issue of paddle, or the mystery of paddle, it's a great sport. It's a mix of tennis and squash. So yes, you play in the cage, I guess you can put it that way, but the points are incredibly long, and what's so unique about paddle, you play literally in any weather. So this is actually the first time I played. I've been playing tennis my whole life, for as long as I can remember myself, but it's really a winter sport. It's very social. So for any of your pickleball players, and there are usually some, well, if you're looking for the next level challenge, check out paddle. So a little bit again about myself. So I'm the founder and president of Capital Square Financial. This is actually the second firm I launched last year. The first firm was acquired by a regional CPA firm. I used to be a partner at that firm. Capital Squared specializes in retirement planning. And what I mean by that, we work with people who are thinking about transitioning or in retirement. That is all we do. Of course, we also support their children. There are 4 of us at this point. We've been growing rather rapidly. We currently manage a little under $100 million for almost 50 families, and we do want to keep it a boutique-style firm. In terms of our investment strategies, they're always individualized. Every single client has his or her own investment policy. There are no cookie-cutter models, so we always start from scratch, and we can really customize it for our clients. Now, I'm not a CPA, I'm a CFA, but I used to, again, work at a regional CPA firm, so one of the unique features of our approach, we're very proactive when it comes to tax planning. So when we meet with our clients, either semi-annual or quarterly, we usually talk about taxes quite a bit. We're full independent, we're a fee-only firm, we always serve as a fiduciary. Essentially what that means, we don't sell any products, and any advice we provide, it has to be in your best interest. Of course, if you want to learn more, feel free to reach out to me directly or visit our website. So, in terms of our seminar today, 529 college savings plans, advanced strategies to plan for college, I'll say 2 things. Even though it says advanced, we will talk about the basics as well. So if any of you are less familiar, that's perfectly fine. We'll talk about the basics. And in terms of, again, I'm looking at the audience here, the focus will be on grandparents. Because, the strategies for parents and grandparents, there's some similarities, but there are also some differences. If you have any questions, please ask. So if it relates to any of the slides that I'm about to discuss, please ask, and I'll try to address it. If it's more of a personal question or requires a longer discussion, perhaps it would be best to wait until the end. So with that, let's get started. So of course, the importance of planning for college cannot be understated. This is a big, national problem. As of last year, we had over $1.8 trillion in student debt in the U.S. We have almost 44 million borrowers that have federal student loans, and there are of course some that have private loans as well. And the average balance per student is more than $40,000. Now, this is one of those times when the averages can really be deceiving. I happen to know quite a few people in their 30s, even late 30s. They're about to be promoted to partner in their law firm. Law firm employees are in that situation, and they're still making, debt payments. So it's a big problem. And for those of you who want to support their children or grandchildren, perhaps this is one of the best ways to do that. In terms of our approach, we usually would focus on this as part of someone's comprehensive financial plan. Usually this comes up that way, and/or gifting strategy. At the same time, you can certainly address it on an issue-specific basis as well. And of course, the question is, well, what is the best way to save for college-related expenses? Now, not to jump to the conclusion, but that's essentially the idea of the seminar today, 529 college savings plans, they happen to be the most versatile tool to accomplish that goal. Of course, you can, pay for college out of pocket, right? Perhaps you can do it out of your brokerage account if you can afford to do so. But if you have time and if you do it in advance, there are many benefits of the 529 college savings plans. Flexibility, control, investment and tax benefits, some estate planning benefits as well. So we'll have a slide for each of those. We'll discuss it in detail. So in terms of the basics, the 529 college savings plans are tax advantaged plans designed for you to save for college, for your children or grandchildren, or for yourself. By the way, you can use those plans for yourself. There's nothing wrong with that if you ever decide to go back to college. There are two types of plans out there. There are so-called prepaid plans, when you can essentially prepay for a certain number of credits or semesters for the student. I'll tell you, they're becoming less and less popular. And the reason that's the case is when you deal with younger beneficiaries, it's very hard to predict that they're going to go to a university, let's say in Maryland or Virginia. So usually for planning purposes, we focus on education savings plans, or they also call them investment plans. And that's going to be the focus of our seminar today. So in terms of the account options, all 50 states in the District of Columbia sponsor at least one type of 529 plan. In Maryland there's one, in DC there's one, in Virginia there are actually 4 of them. I asked Steve in terms of the residency of the attendees today, and he mentioned that most of you are from Maryland. So we'll focus on the Maryland options today. There are some similarities, a lot of similarities with other states, but there are also some differences. Now, most brokerage houses, Schwab, Fidelity, Merrill Lynch, they offer 529 plans. There are some potential issues with that approach, specifically in terms of the internal expenses. I tend to always point that out. With state-specific plans, essentially all of them, they have a board of trustees that oversees the plan, so they always negotiate on behalf of the investors, essentially. When you deal with brokerages, well, watch for those additional expenses. What are the benefits? Well, there are 2 types of benefits in terms of the tax benefits, I should say. There are upfront deductions on your contributions to the plan. The most important part here, your contribution has to be into your state-specific plan. So in Maryland, it would be tier price. That's important. Any fund that you contribute, any funds that you contribute into the account, grow tax deferred and essentially tax-free as long as you use the funds for so-called qualified expenses. And we'll talk about what those are, and we'll also talk about what non-qualified expenses are. There are some estate planning benefits as well. We'll touch on that too, meaning transferring assets into the plan so that the next generation can benefit from that. There are some restrictions too in terms of the contributions, specifically your deductible contributions. So in Maryland, it's $2,500 per beneficiary per year. So you can contribute more than that. You just have to deduct those contributions over the future years. In terms of the withdrawals, as I mentioned earlier, again, they're designed for college-related expenses, and there are penalties if you take the funds out for other purposes. In terms of the investment options, even though I put it under the restrictions, I don't really sort of think of it that way. It's just that most, specifically state-sponsored plans, they'll give you anywhere between 10 to maybe 20 choices. And I would say for most people, that's adequate for investment purposes. So we'll start with choices and timing here. So we'll start with that piece. So in any 529 college savings plan, you'll have two types of choices. You'll have the so-called target date funds. So as an example, let's say Vanguard Target Date Fund 2045. That would be the name of the fund. And the assumption behind the strategy of this fund is that the beneficiary would presumably use the funds right around 2045. So when we work with young beneficiaries, newborns as an example, usually that's the approach we would take. We'd put them in the target date funds and keep it there up until they turn 13, maybe 14 years old. And that's when we consider switching, potentially, to so-called static investment options that don't change over time. It's going to be index funds, it can be actively managed funds, but the idea here is to essentially have more control in terms of how the funds are invested. Well, in some sense goes without saying, but just like with any investment account, if you need to use the money and the markets are down by 20 or 30%, chances are that's going to create an issue. So that's why, again, when someone turns 13, 14 years old, we want to review that. Now, in some sense, contrary to what I mentioned earlier, the state-specific plans are not always the best choice. And to give you an example of when perhaps that would not be the case is when you're thinking about making large lump sum or one-time contributions into the plan. Because again, once you start analyzing, once you start digging deeper, those internal expenses, even in a plan like T. Rowe Price in Maryland, they can be rather high when compared to other plans. So as an example, if someone wants to make a larger contribution, let's say $100,000 plus, wants to pre-fund someone's education, the best choice as of today is actually the Utah plan. The Utah plan. And the reason that's the case is because it has the largest number of well-performing, low-cost investment options. And in terms of their administrative expenses, they're also the lowest in the nation. So that's just one piece. Now, what is the best time to contribute? Well, the best time to contribute is in anticipation of the child or grandchild. So this cute little baby, this is actually my son Nikolai. So, and that's me holding him when he was first born. He's 80 years old now. So how would you contribute for someone who's not even born yet? Well, you would create an account for yourself. You would make a contribution into the account. You'd invest it the same way you would normally do. And then once your child or grandchild is born, you would simply change the beneficiary. You would need that person's, of course, full name and social security number. It's just a form to complete. One of the questions I get every so often, well, should you contribute if your child or grandchild is already in college? So you don't necessarily have that much time for the funds to grow. Well, the answer is potentially, or it depends, because again, if you contribute into your state-specific plan, you still get that upfront deduction, you still get some tax-deferred growth, and again, all plans will allow you to invest in essentially a fixed income type of option that just essentially gives you 3 to 5% usually. So potentially, but certainly not as beneficial as if you're dealing with someone who's younger. Any questions at this point? Good. Okay, so in terms of the flexibility, in terms of the idea of having multiple plans and overall flexibility of the planning process, that is again one of the benefits here. One thing I want to emphasize, because this is a common misconception, is that the deductible contribution limits are per beneficiary in most states, including Maryland and Virginia, not in DC. In DC, it's actually $4,000 per single tax return or $8,000 per joint. So what happens is if you have multiple children or grandchildren, you can essentially fund all of those accounts and deduct your contributions in the same year. So as an example here, let's say we're working with grandparents that have 10 grandchildren and they want to support them all, and as part of the process they want to potentially reduce their taxable estate. Well, how can they possibly do that? They would open 20 accounts for each of those grandchildren, or 10 of them specifically. They would fund them $2,500 per beneficiary. That's the annual deductible amount. That gives you a one-time contribution of $50,000. Now, in terms of your tax deduction rate, it's 8%, anywhere between 6 to 8% in Maryland. I like to think, with my investment background, of it as an immediate rate of return, right? So if you make a contribution of $50,000 in this case, and you get a tax deduction on the Maryland side of 8%, that gives you an immediate rate of return of $4,000. So that's important. In terms of the additional tax benefits, this is more of a technical point. This is something of course for you to understand, perhaps your CPA or your financial advisor. In each state, there are so-called carry-forward provisions, at least in most states that I know of. In Maryland, it's 10 years. And what that means, if you ever make a contribution above the annual deductible amount, you can actually deduct the remaining funds over the next 10 years. The biggest issue here is people forget to do so. So that is truly the biggest issue. So someone needs to create some kind of spreadsheet and keep track of it, or again, perhaps your CPA or financial advisor will do that for you. The carry forward is unlimited in Virginia, and it's only 5 years in DC. But again, we're focusing on Maryland today. So yeah, back to the estate planning benefits. There is this super funding provision that applies to the 529 plans, and essentially it allows you to front load your contributions into the plan. So a perfect example is, again, someone is talking about their legacy. They really want to support the next generation. How can they do that? Instead of course, contributing $2,500 per year, which is beneficial, they can do up to $90,000, again, per beneficiary. For a married couple, it would be $180,000. They would need to work with a qualified CPA who understands how it works, because you would actually need to file a gift tax return, and then each year you would have to do it. But once you make the election, it actually does not reduce your lifetime exemption. And that's, again, one of the benefits of specifically of the 529 plans. Now, the bullet point here at the bottom comes up every so often. So in DC and Maryland, the maximum account value per beneficiary can be up to $500,000. I've never seen such a large account myself. I'm sure they exist. The largest account I've seen was right around $300K, which is what you would need for some of the top schools in the nation. In Virginia, it's $550,000.
Alex, could I ask a question?
Absolutely.
So I was really glad you talked about front loading, because years and years ago you could front load $55,000 and that kind of thing. Is there any downside to front loading? And you're the financial advisor here. Is there any downside of pumping all that money in at once? I know there's no downside as far as estate tax and that kind of thing. But is there a downside as far as dollar cost averaging or anything like that? Is it better to put in money over time, or is it better just to front load?
Yeah, so great question. Thanks, Steve. So again, 529 college savings plans, they work exactly the same way as your normal investment account. So that approach would be the same. So let's say you made a contribution of $180,000 into the account. If you prefer to do so, if the beneficiary is very young, it's a newborn, let's say, chances are we'll just invest the funds all at once and let it fluctuate, let it do its thing, essentially. If someone is, again, older, let's say 13, 14 years old, you can always allocate a portion of the contribution into a bond fund or a fixed income fund, so you can protect it this way. But essentially, it works the same way as you would deal with a normal investment account. Yes, please.
If you do front load, do those dollars go out of your estate in terms of taxation?
2 years. So it's considered to be a completed gift as long as it's there for 2 years, it's out of your estate. Now, if with this particular, actually I take that back partially, if you die within the 5-year period, right, so the remaining funds would go back. So the assumption here is that you wouldn't die within the first 5 years of making the contribution. Yes?
Are there any limitations as to how frequently you can create a 529 for the same person? And my question on that is, create 529, kid goes to college, close, and then afterwards, X number of years afterwards, kid wants to go back to normal college, you want to help them tuition, one option would be the one that 529. Is that possible or is that prohibited?
Absolutely. Absolutely. You can open a new account for anyone at any time. You don't even have to close it as far as I know. Usually that's what people do when the account reaches zero balance, but you don't have to close it. Again, from that perspective, as I mentioned earlier, it very much works like a typical investment account. So, and some of the platforms, not to get too technical here, they're just like a typical, investment platform, essentially. Any other questions on this? Okay. So, FAFSA, and this is one of those topics you can easily spend an hour talking about financial aid, which we will not do. We'll mostly focus on how, again, saving in your 529 plan potentially impacts your federal aid. So for the purposes of this example, let's say we're dealing with a $10,000 account. Well, if this account belongs to the student, potential reduction in financial aid, depending on other factors such as income as an example, can be as much as 20%. So relatively significant, $2,000 in this example. If the parent owns the asset, which is usually the case, potential reduction in financial aid is only 5.64%. So in this case, the reduction would be $564. That's the most common. Now, prior to the FAFSA Simplification Act of 2020, it was rather challenging to, when you start working with multiple generations, to include the grandparents' assets because they were considered to be third parties for the purposes of FAFSA, and they would reduce the potential federal aid by up to 50%. So what we used to do, again, when you talk with both sides essentially, the parents would fund the first 2 years, and then once you file your final FAFSA, that's when the grandparents would pay for the remaining education. That is no longer the case. Effective January of this year, they would refer to it as a grandparent loophole. Grandparents' accounts no longer count toward FAFSA. This is incredible. I first learned about this 4 or 5 months ago. At this point, I've done some research. I talked to multiple people. As we speak today, that is one of those things. So what does that mean? Again, for any of you who are thinking about creating these plans for your grandchildren, it makes it even more beneficial for you to do so.
Can I ask a question?
Please, yeah.
So if we're trying to maximize the tax benefits, a parent can maybe make a gift to the grandparents with the understanding that they would open up a 529 for their grandchildren, right?
Absolutely. See, it's amazing how that was not the case prior, as I mentioned earlier, but at this point, absolutely. $18,000 a year, that's easy. So distributions from the 529 plans. Again, as I mentioned earlier, there are 2 types. There are qualified distributions, and those are tax-free, and that's essentially what you want to plan for. In my experience, I really don't know that many people had enough money for non-qualified expenses. In most cases, it's really used for that purpose. Tuition, room and board, books, computers, there's actually a list of other items, but this is the most common. Now, there are certain expenses that do not qualify. Essentially, the list would be very long because it's everything besides the qualified expenses. So a car purchase is an example, so that would not qualify. College test prep, that would not qualify. If you find a tutor for the student, that would not qualify. College application fees. So sometimes people ask me these questions, but those are not qualified expenses. Now, in case, and there's going to be a separate slide when we talk about this more, in case you make those non-qualified expenses, there's a 10% penalty that applies on the growth portion only, and you have to pay taxes at your ordinary income tax rates on the growth portion only, and I'll talk about that separately. As part of the original Secure Act of 2019, you can now use up to $10,000 to repay student loans. That's the lifetime limit. So on the surface, it sounds like a good choice. I don't know pretty much anyone off the top of my head who would use this feature. Because the problem is if you have student debt, then chances are there was not much planning done ahead of time. But now we have this available. Under the TCJA, or the Tax Cuts and Jobs Act of 2017, you can also use up to $10,000 per year to pay for K-12 private school tuition. Yes?
Is there an annual qualified expense limitation
For?
for dollars? Say if you have $100,000 in a grandchild's account, can they use that $100,000 the first year if they go to college?
Absolutely. No limitation. That's such a great question. No limitations whatsoever. As long as it's presumably for qualified expenses. If not, then you pay taxes and there's a penalty. So back to the fact that you can now use up to $10,000 a year to pay for K-12 private school tuition. That is a more beneficial feature. I'm personally not a big fan of it, and the reason that's the case is because the idea again behind the 529 college savings plans is to save for college, and you usually benefit from having more time. Now that said, though, if you do the planning and somehow, some way you realize that your child or grandchild is going to have a scholarship, and you will no longer need the funds you already saved in your 529 plan, well, again, that gives you that additional flexibility. Just not a very commonly used feature. Okay, so control of the 529 plan. This looks like a short slide. In my opinion, that is perhaps one of the primary reasons why grandparents decide to take this approach. And again, I'll give you a little bit of a background behind it. Usually when you work with parents that want to save for their children's education, it's a pretty straightforward conversation. You have 2 daughters, 3 and 5. How much do we need to save to pre-fund their college, presumably, by the time they go to college? It's very different with grandparents. Usually right around the holiday season, maybe third, maybe fourth quarter, you start having that conversation. They want to make gifts to their loved ones, to their children, to their grandchildren. Every so often they want to make larger gifts, thousands of dollars, perhaps tens of thousands. Now, one of the issues they have is, let's say they give the money to their parents. There's no certainty whatsoever that the parents are actually going to use the money for the benefit of the grandchild. And I'm not trying to generalize too much here, but you tend to have that conversation. If they give the appreciated stock, same issue, right? Even though that can be held in their account. With the 529 plan, this is truly a gift with a predetermined purpose. Why is that? Well, as the account owner, you retain full control over the account. Full control over the account in terms of the investment choices, in terms of the distributions, in terms of the timing. You can always change the beneficiary if you have multiple, again, grandchildren, and one of them is no longer doing what you want them to be doing. You can always change the beneficiary that way. The beneficiary has no direct access to the funds. In fact, you don't have to even share it with them. You can mention that start saving some for your education. You don't have to provide any amounts to them unless you want to. Now, this is again one of those things. Usually, when you start working with both sides of the family, I usually suggest that there's some planning in place so that people don't overfund those accounts. But at least technically speaking, again, you don't have to share. So again, the bottom line is, when you start talking about those options, sometimes the fact that you fully control the money really makes it, the reason why people establish them to begin with. Okay, so let's say you're lucky. That's perhaps the best way to describe it, and you actually overfunded your 529 plans. What are your options? Well, you used to have 3 options, now you have 4 options. You can take a non-qualified distribution. And as I mentioned earlier, you would have to pay ordinary income taxes on the growth portion only, plus there's going to be a 10% penalty. So if you invested $10,000 in the account, it increased in value to $12,000, only $2,000 would be taxable to you. Now, what happens if the current balance is less than the amount that you contributed? I actually had a couple of experiences like that. Well, there's no taxes to pay, right? You contributed $10,000, the balance is now at $9,000. You take a full distribution, there's no growth, so there's also no penalty. It's a rare situation, but it actually happened. You can change the beneficiary to a qualifying family member. That is perhaps the most common approach. It doesn't have to be a blood relative, but it has to be a relative up to your second cousin. So a lot of different choices. There's actually a list of potential family members. If the account, you can change the account ownership to the child or grandchild. And presumably you'd want to do that if they're in a lower tax bracket. So then they can take a non-qualified distribution and use the funds, as an example, to buy a car or to make a down payment.
May I ask a question?
Please.
So assume a parent has a 529 plan for a child. The parent is the owner, and he or she dies. Who then becomes the owner of that plan, and how would that be accomplished?
Yeah, so every account application that I know of, certainly in Maryland, will have a successor owner section on the application. So for married couples, usually it's the surviving spouse, same thing for the grandparents. So once that happens, again, the successor owner is in control.
So as long as those beneficiary designations have been completed, the 529 plan would not become a probate asset.
That's correct. Correct, yes. So this is, don't quote me on that. So the last time we completed this application for someone online, it wouldn't go through until you select a successor owner. So if you do it on paper, they will most likely process it as is without the successor owner. When you do the online application, it's one of the sections with an asterisk, so you have to complete it. Yeah, that's right, for Maryland. Okay, so the final point here is actually very interesting. It creates a lot of interesting opportunities. I don't think anyone implemented them yet, because this just became active essentially in January of this year. So under the Secure Act 2.0, you can now, or the beneficiary can now convert up to $35,000 into his or her own Roth IRA out of the 529 plan. Again, we're trying to address the issue of overfunding your accounts. Now, there are some rules that are in place. The first one is perhaps the most challenging one to keep track of, as I'm thinking about it, is the fact that the account needs to be in place for at least 15 years. Right? So again, as you start thinking about it, you funded this account when someone was 2 years old. Right now they're 17, 18 years old. Perhaps you don't no longer need the money for any reason. You can start doing the conversions into this person's Roth IRA. Now, when that happens, at least under today's rules, it's limited to the annual Roth IRA limit. So for those under the age of 50, it's $7,000 per year. So this would have to be done gradually, and only the beneficiary can do this. So not the account owner.
Does the beneficiary have to have earned income to do the Roth designation?
See, that's another one. It's interesting. At first, when I first heard about it, I was like, wow, this is amazing. But that's one of the issues. You have to have earned income to do the conversion. It's possible that they'll modify it. Because again, I really do not believe anyone implemented the strategy yet. You can just start planning for it. But still, again, what they're really trying to address is this concern at least some people have, of overfunding their 529 plans. Well, with that again, as I mentioned earlier, I very much hope that you agree that if you ever want to fund someone's college education, 529 plans are the most versatile tool to do so. Please.
Especially since we're getting to community college here, is that only for academic college or trade schools?
Accredited institutions is the technical term. So one of the interesting parts, and I discovered that a few years ago, every so often people want to send their children outside of the U.S. So there are hundreds of universities outside of the U.S. that will accept the 529 plans. There's a long list of them. So there is that too. Yes, please.
Earlier in your discussion, you mentioned a specific 529 plan that you recommended because you thought it had less expenses than some of the other plans, and I can't remember what the name of it was.
The Utah plan. Yeah. So it's consistently ranked in the top 3 essentially. We have multiple clients in the Utah plan. It's very easy to use. Again, we're talking larger contributions, right? If someone is thinking about several $1,000s, I would still stick with the state-specific plan because you get that upfront deduction. But once you go, let's say 100 plus, without doing much math here on the spot, it usually makes sense to save on the internal expenses in the long run. Yes, please.
I think adding to her question, my question is if a grandson wants to go to vocational training, is that at an accredited community college, would that be covered, or is it only accredited courses? They're non-accredited vocational courses like HVAC or electrical or plumbing, and then there's the academic track.
Okay, so I had this issue with one of the clients, and I cannot remember what college. It was a similar situation. The solution was to simply call them and see if they qualify. I would rather not give you like a blanket statement because I do know, so I used to live in Norfolk, and there was this IT school out there which actually went bankrupt. And then the bottom line is they were like a for-profit institution. They were positioning themselves as an educator that was not that. So sometimes the names can be rather deceiving, so I would rather not give you any kind of direct answer to that question. I would just contact the...
This college, this community college, which is part of the state of Maryland, has non-credit vocational training courses, but they're listed separate from the academic courses and degrees. You're right, calling this college a
Would rather not go again one by one, sorry.
Yeah, no, that's fine.
Alex, I have 2 questions, real quick. One is, you've mentioned overfunding several times. So how much of a problem is that, and is there really a risk in overfunding? And number 2, let's say someone is invested in a state program that does have higher fees, and there's, it's a big, they've contributed a lot of money. Is there a way to transfer it to another 529 plan like Utah?
2 great questions. So the first one, in my opinion, again, this is a little bit of a blanket statement. It is not a problem. I cannot think of any people or many clients that we work with that overfunded their children's or grandchildren's accounts. And when we're talking about that, okay, let's say there's $10,000 remaining. Again, you have so many options to deal with that at this point. I mean, again, it can potentially be an issue. So transferring funds out of your state-specific plan to a plan such as Utah is absolutely a possibility. However, at least technically speaking, the state of Maryland would want to recapture the income taxes that you saved when you made the contributions to the Maryland plan. So I spoke with very highly qualified CPAs on the issue, and it's not really enforceable. But it's just very tough. But technically speaking, when you look at the rules, right, so when you get a tax deduction, by the way, there's no federal tax deduction, I apologize, I didn't mention that, state-specific only. When you transfer, you're supposed to, return the money. It's not been particularly enforceable. Yes, please, we'll get back to you, please, yeah.
If a grandparent opens an account and other family members contribute, like parents or other grandparents contribute to the same one and get the same tax benefit if they're Maryland residents?
Yes, it doesn't have to be in your own plan. Usually don't recommend that strategy.
Oh, why is that?
To keep track of the accounts. Yeah, I see what you mean, it can be done. Usually just, if you're talking about with multiple accounts, yes, create a spreadsheet and keep track of it yourself by account and by beneficiary. I wouldn't recommend, let me know it's possible. Please, yeah.
Is there any way to move pre-tax dollars from an IRA to a 529?
No. You can move the UTMA accounts. Are you familiar with Uniform Transfers to Minors Act? So the UTMA accounts that can frequently be used for non-qualified expenses along with the 529 plans, they can be moved into the 529 accounts, but in that case you will no longer be able to change the beneficiary. Rarely recommended, but it's possible. Please, yes.
Does stepchildren count?
Yeah, absolutely. That's what I mentioned earlier. They don't have to be your blood relatives. Stepchildren, absolutely. So the way it works, actually I had an interesting nuance that happened. One of my clients, they had a person who came to their house to help with, house-related tasks, housemaid. So they wanted to support her daughter. So they created a 529 plan for the daughter of their housemate. The issue with that approach is you get a tax deduction and all of that, but the beneficiary can now only be changed to that person's relative. It's such a, but I remember looking into that. But if you create it for someone who is not your relative, which you can absolutely do and get a tax benefit, you would not be able to change the beneficiary to your relative. So it would have to be that person's relative. Any other questions? All right, well, this is great. Again, thanks so much for joining us.
Okay. Another hand for Alex, Steve, Mary. And also to Danny about for recording today's event. And to me. Thanks again for attending. And we'll be sure to have our recording out to you very soon. And also on the horizon, we'll have our second quarter event, our actual second quarter event, since this was the first quarter event actually. We'll have that sometime probably in mid-June. We'll announce that very soon. And also our annual social event, which will be coming up this summer. We'll have that announced soon. And also already on the calendar is our annual client event, which is November 9th at 10 Oaks Ballroom again. It's a beautiful place. If you were there last year, you already know that. If you didn't come last year, please do. We had a wonderful time. It was a great event. And 10 Oaks Ballroom is also fully refurbished. Actually, last year's event that we had was the last event that they had before they fully refurbished the thing. So it's going to be even more beautiful this time. And so planning is already underway. And we have a great event planned. I'm not going to tell you our theme yet. So stay tuned. So enjoy your weekends, and please drive safe, and we'll see you again soon. And thanks for being a member of the Client Care Program. Have a great day.